Welcome, and let's get ready to exercise our brains.
Welcome to today's Concerned Educators Against Forced Unions on Lunch Break. And our website's also located at CEAFU.org. Thank you for joining us live and on our website, YouTube, Facebook, Vimeo, and other sites where our recordings are available. I encourage you to consider joining us during the live events so you can actually put our guests on the spot to answer your questions. And speaking of being on the spot, let me begin by introducing today's guest. Welcome, Glenn.
Thank you.
Glenn Taubman has been a National Right to Work Legal Defense Foundation attorney for over 40 years and has protected employee rights in a variety of federal and state cases. These cases include union violence against employees, labor unions' abuses and fines and discipline for those who won't toe the union line, in cases involving union attempts to have employees fired for refusing to pay compulsory union dues. You may have seen Glenn previously as he testified before Congress in favor of employees' rights on numerous occasions. Glenn is a sought-after expert and is often interviewed and is a contributor to many legal news and journal publications. Today, Glenn will expose union institutional bigotry against employees' religious liberties in a case brought by the National Right to Work Legal Defense Foundation and the Fairness Center on behalf of Professor Abraham Goldstein and 5 other professors who teach at the taxpayer-funded City University of New York, usually or commonly called by its abbreviation CUNY, C-U-N-Y. Glenn, welcome, and thank you for being here. Would you please start by giving us a little background about the City University of New York professor's case and introduce Professor Goldstein before we show his video for the National Right to Work Awards Dinner?
Of course. Thank you, Don. Good afternoon, and thanks to everyone, to our viewers, for being part of this event. I'm happy to be here. In a few moments, excuse me, in a few moments, you're going to see a video made by one of my clients, Professor Avraham Goldstein. I want to introduce Professor Goldstein in the video and set the stage to discuss the critical issues that are being litigated in this case. Then we will have some time for Q&A at the end. Professor Goldstein and 5 of his colleagues work for CUNY, the City University of New York. They are public employees, most of whom reluctantly joined the Professional Staff Council Union many years ago when membership or the payment of dues was mandatory. 5 of the 6 professors in our case are Jewish, and 1 is not. 2 things happened in recent years that make this case so interesting. The first is that the Supreme Court in 2018 issued the Janus decision, a landmark national right to work victory that freed all public sector workers from having to pay a dime in union dues. Janus recognized that employees' rights of free speech and association are violated if they are forced to pay dues to a private organization they oppose. And the second thing that happened is that in 2001, a radical group of leaders took over at the PSC Union and began pushing resolutions and statements on a host of issues having nothing to do with collective bargaining at CUNY, such as attacking Israel as an illegitimate settler colonialist country. The professors rightly viewed this PSC activity as anti-Semitic and anti-Israel. When they sought to resign their union memberships and stop paying dues, they were able to do so, but only after some months of wrangling with the union and the university. And they were able to stop their dues solely because of the Janus decision. But that did not solve the professors' real problem. The problem is that even though they were able to resign from the union and stop paying dues, these professors, like all other professors, are still stuck in a bargaining unit, exclusively represented by the PSC union as their sole bargaining agent. Under New York law, they are forbidden from speaking to their own employer about their wages, hours, and working conditions, and the employer cannot speak to them because the PSC union has been designated as the professor's exclusive bargaining representative. So, Even though the professors despise the PSC union as an anti-Israel and anti-Semitic organization, and the PSC despises them based on their religion, ethnicity, and support of Israel, the professors are stuck with PSC's supposed representation. And this problem plays out all over the country. Although the Supreme Court got rid of forced dues in the public sector, the Janus decision left in place forced exclusive representation by a monopoly union. The professors have no choice and are subject to the union's negotiations and contracts whether they want such representation or not. I liken this to a situation where a state like New York assigns a specific lawyer to you. So if you want to file a lawsuit against your neighbor because he damaged your property, you can do so, but only if you use the state-assigned lawyer as your exclusive legal representative. And even though that state-assigned lawyer hates you based on your religion or ethnicity, and the feeling may be mutual, you have no choice but to use that lawyer because the state has assigned him to be your exclusive legal representative. And so that's basically what we have here: forced association and forced representation as a matter of state law by people who want nothing to do with this private organization that tramples their rights. So we're litigating a groundbreaking case to take Janus to the next level by seeking to have not only forced dues declared illegal, which happened in Janus, but to have exclusive representation declared to be a violation of employees' free rights of free speech and association. So now, with that introduction, let's meet Avraham Goldstein and hear his compelling story. Thanks.
Hello, my name is Avraham Goldstein, and I would like to thank National Right to Work for granting me the Applegate Award. Let me briefly introduce myself and tell you our story at the City University of New York, which is also known as CUNY. So I was born in the former Soviet Union in 1971. 2 years before I was born, my parents asked the Soviet authorities for permission to leave the Soviet Union and immigrate to our homeland, the state of Israel, being we're Jewish. Soviet authorities denied my parents and our family the right to leave Soviet Union for 15 years until 1986. During these years, my family and I experienced persecutions for our Judaism, which we practiced, and our Zionism in the Soviet Union. In Israel, I got my bachelor's degree in mathematics from Technion, and then I came to the Graduate Center of CUNY to pursue my PhD in mathematics. It was in 1994. In the beginning of 2003, I defended my PhD, and during these years, I worked in Lehman College, which is part of CUNY, as adjunct lecturer of mathematics. And in 2006, I got a tenure-track assistant professor position in the mathematics department of the Borough of Manhattan Community College, which is also a part of CUNY, and I'm still at the Borough of Manhattan Community College. So as you can see, I've been involved with CUNY for over 25 years now, in one way or another. So in the fall of 2018, I was approached in my classroom in BMCC by the representative of the PSC CUNY union after I finished my class. And this representative told me that due to some lawsuit which was recently won, and that was Janus, of course, but I was not aware at the time, we all are automatically not members of the union anymore unless we reapply by filling out and signing this blue card. And the rep gave me the card. Being a little bit careful, I told the rep that I can't sign something before I talk to other people, study the card, and so on. So I took the card, I went to the math department, and I asked my colleagues there who are more aware of what's going on with unions and bureaucracy and all that stuff. I'm more into research and teaching. So my colleagues told me, yes, we all were told about this card, and this is what everyone does, and this is fine. So I filled out the card, and there were 2 places to sign on the back, and unfortunately, I didn't do a due research. I signed And about 2 weeks later, the rep came again and asked me if I decided to sign the card and submit it or not. So I told the rep, yes, I decided to do it. And the rep told me, good, because otherwise your benefits like glasses, which are covered by the union, and prescription drugs would fade out because the union would not continue giving it to you without you being the member after some time. I said, okay, that was not my calculation why I signed the card, but okay, even better. And I gave the card back. Okay. Now let's move to 2021. In 2021, there were elections in the PSC CUNY union, and a new group, much more radical, outspoken, and extremist, came to power and started to push forward their agenda. The union started passing resolutions about Chinese-American relations, accusing the Biden administration in, I believe, May of 2021 in being racist against China. Then there was a resolution in June against my country, the state of Israel, accusing Israel of being a settler colonial state from 1948 and committing genocide of Palestinian population. At that point, many of my colleagues at CUNY, Jewish colleagues and non-Jewish colleagues, and myself decided that we no longer can be members of that union, and we wanted to resign. So we wrote our resignation letters. At that point, we were informed by the union, or some of us were informed, that we are committed to the union. We cannot resign. Those of us who signed this blue card are not allowed to resign the union. We have only a 10-day per year window when we can resign. If we try to resign at any other time, our resignation is not fully is not a full resignation, and the dues will be still collected unless we resign during those 10 days a year. Now, most of us didn't even get that reply from the union. For example, I sent my resignation and there's nothing. The dues are still being collected. At that point, I wrote to the H&R department of Borough of Manhattan Community College, informing them that I resigned from the union. They ignored it. And then I was informed by my colleagues that some HR departments told us that they are not allowed to talk to us. The union, being our sole representative, is the only one who can tell them that we are no longer members of the union. So that situation was unbearable. And at that point, I contacted the National Right to Work. The National Right to Work took our case. It was me and several of our colleagues, and helped us to bring the case to the court. What I found out is that even after I resigned from the union, and I did do it during those 10 days later on, I caught those 10 days, I forced the union to tell me when those 10 days are, and I made sure to resign during them. Even after I did that, the union is still my exclusive sole representative, and I cannot free myself from that dreadful, horrible representation. And when the union comes out with political statements, which should not be part of what the CUNY union representing the instructional staff at CUNY should be concerned with. And when they say we have 30,000 people behind us in our statements, I am still counted as one of those 30,000. And when the union makes a decision to do certain things in terms of our rights or giving up our rights, they still do it in my name, even though I don't want them to represent me in any form or way. So I'm very thankful to the National Right to Work and to the other groups who help us, several professors in CUNY, in our lawsuit against the PSC CUNY union to free us from being misrepresented by the union without our consent and against our will. Thank you very much for listening to me, and I'm looking forward to the times when in United States of America, people will be able to decide themselves who will represent them and who will not represent them. Thank you very much.
Well, Glenn, he's a pretty powerful spokesman, I would say. He certainly has a great life story.
Yes, he is passionate and a wonderful story. And I would say, a sad commentary that a refugee from Soviet Russia has to come to this country and be told, well, we're going to assign a forced representative to you, and it doesn't violate your free rights of free speech and association for that to happen. Sadly, it happens all over the country because so many workers are subject to forced representation, whether they like it or not.
Now, this is, I guess, a public sector situation. Now, is this common in the private sector as well?
So, yes, I mean, it is. I mean, the problem of forced representation runs across the board. Anytime you have collective bargaining and monopoly unions, the people are forced to be represented. They're placed in a bargaining unit and they're given a representative, whether they like it or not. In fact, it's even worse in the private sector because in the private sector, you may not only be forced to have this exclusive representative, but you might also be forced to pay some amount of the dues to them. If you live in a right to work state, and there's approximately 25 right to work states, you wouldn't be required to pay dues if you're in the private sector. If you are in a forced union state, New York, California, Illinois, Massachusetts, whatever, you are both forced to have the union as your exclusive representative and you're forced to pay dues to them. That's the ultimate indignity. So this problem is very acute in both the public sector and in the private sector. The only good news is because we won the Janus case for public sector employees, they don't have to pay anything no matter where they live.
Well, that kind of makes me think about there's a lot of people not under the yoke of monopoly bargaining, but have heard about the foundation's victory in the Janus v. ASME case. And then so they might ask, didn't Janus go far enough to protecting workers' rights? I mean, how is this not allowing them? I mean, why didn't Janus allow them to escape this kind of, I guess, bigotry?
Well, so Janus was a groundbreaking decision. It was an earth-shaking decision that we at the National Right to Work had been litigating cases to lead up to Janus for 30 years or more, since the 70s, when the Supreme Court in Abood, in a case called Abood, upheld forced dues. So Janus was a groundbreaker, but Janus was a 5-4 groundbreaker. There were 4 dissents against the ruling in Janus. And for better or for worse, I suspect that the Supreme Court felt like this was as far as they could go to hold their 5-4 majority. And the next step, getting rid of exclusive representation, is another heavy lift. And we continue to litigate cases like the Goldstein versus CUNY case to push that issue. But it is a tough lift at this point. We're hopeful that the Supreme Court will take this particular case because of how compelling the facts are, that it's not just forced representation by any union, but forced representation by a union which completely violates the religious liberties rights of its own members by telling them that they have to be part of a union that really just totally destroys and denigrates their own deeply held religious views.
Well, it's kind of interesting to see how much kind of there's kind of politics at the Supreme Court, where they're trying to make sure they can get a majority together before they even consider a case. It sounds like is that common?
Well, the Supreme Court is one of the 3 branches of government subject to the same sort of political push and pulls as every other branch of government. And although I'm sure they make some effort to appear to be above politics, these issues become very political. And so the Supreme Court, for better or for worse, they did not get rid of exclusive representation in Janus. I mean, truthfully, that issue was not squarely presented in Janus because we were just trying to get rid of the forced dues. But the work falls to us now to push the envelope to the next logical level, which is getting rid of monopoly bargaining, exclusive representation for people who don't want it. And like I said at the beginning, I liken this to a situation of the state assigning you a lawyer or assigning you a doctor or assigning you any other exclusive person who allegedly works for you, but they may not like you and you may not like them. But the state comes along and says, it doesn't matter what you like. It doesn't matter what you want. It doesn't matter who you want to associate with. We have determined that this is your representative. End of story. And that's wrong.
I mean, I guess it seems to me, looking at some of the historical records, that the Supreme Court and courts across the country before the 1930s realized, hey, this is wrong. And then after that, somehow the courts changed their mind, and they just seem to think monopoly bargaining, collective bargaining, and forced dues were okay. I mean, is there? I mean, what? How are you going to get them to change their mind? I guess.
Well, we're going to
apparently change their mind.
We're going to get them to change their mind by continuing to bring these compelling cases forward. And the Goldstein versus CUNY case is one of the most compelling. And there are others, and there will be others, because this is who we are in pushing the agenda of freedom and liberty and individual rights and individual choice. So we're not going to stop. But it is true that the Supreme Court in the past has upheld exclusive representation monopoly bargaining. But every time they've done it, they do it with a little caveat, and they say, we would not allow this in any other context. Labor relations are different, and we recognize that this is a huge impingement on people's free speech and association rights that wouldn't be allowed in any other context. That's what they have said. And so we come forward in cases like Goldstein and say, well, why is it allowed in this context? It makes no sense, and it's grossly unfair to allow it in this context and any context. So we will continue to bring these cases forward. We will continue to point out to the Supreme Court that by their own logic, this should not be a carve-out for union bosses and union privilege, that people's individual rights should prevail over the collective wisdom of the states and of union bosses.
Well, okay. No, that also, well, not necessarily that, but when we did you guys argued the Janus case, it obviously narrowly only applied to the public sector unions and public sector. Now, if you should win this case, it seems to me that this goes beyond the public sector, and it shouldn't be narrowly defined just for public sector employees. Is that what you're saying, or am I just overly optimistic again?
No, I think a ruling here that said that exclusive representation is unconstitutional because it violates people's free speech and association rights would also apply to the National Labor Relations Act. I mean, it would be a dagger in the heart of the National Labor Relations Act and the Railway Labor Act, because the concepts are really exactly the same. I mean, you have a federal statute that is based on exclusive representation. If the Supreme Court said in the Goldstein case that exclusive representation was unconstitutional, I don't see why that wouldn't apply across the board.
Well, that's kind of makes me even more hopeful, or more excited about the possibility.
Well, we're always hopeful.
That's right. I guess I am always. That's true too. But so I get where are we exactly in the, I guess, the trajectory of getting this before the Supreme Court? Where's the case stand now? What kind of timetable do you see for it to go?
Okay. The U.S. District Court in New York ruled against Professor Goldstein and his colleagues, I want to say about 6-7 months ago. I don't have the exact date. but the district court felt that it was bound by the existing law and that it could not strike down exclusive representation, although it recognized that this was a huge impingement on the professors. We appealed to the U.S. Court of Appeals for the Second Circuit in New York. Oral argument was held a few months ago, roughly, I want to say November of 2023. And here we are, February of 2024, and we're awaiting a decision. We'll see how that comes out. And an appeal is likely, no matter who wins or loses. And the next stop is the Supreme Court. So it depends when the U.S. Court of Appeals issues their ruling, but I would imagine we will get that fairly soon. And then we'll be looking at filing petitions for certiorari with the Supreme Court into the spring. And probably by when they open up the new term in October of 2024, we should know whether they'll agree to hear the case or not.
That seems soon. I kind of like that. Now, as we talked about, that this could also affect private sector employees. So I'm assuming, so I'm going to ask you, are you seeking or do you want private sector employees to contact you if they also are having similar situations at their workplace?
We're happy to have all employees facing union abuse contact us. We screen all the calls. We talk to everybody. We advise them as best we can of what options are available. And sure, anybody who wants to call us and bring these issues forward, there's different options short of going into federal court. There's all kinds of options depending upon what people want and what they think is in their best interest. So sure, let people, workers, private sector, public sector, they can all call us. We're on the internet, nrtw.org. We're easy to find.
Okay, Glenn. Well, thank you very much for being here with us today. And is there anything else you'd like to add? I mean, I was impressed with the professor. I've met at least one of your other professors involved, and they seem, I mean, I guess most professors are clear about, the way they feel about things. I think they present very well because they've thought about what they're doing.
Thank you. Well, these are all committed people, and we're very honored to have them as our clients. And all I would say in conclusion is thanks to audience members for listening in. Feel free to contact us with any questions or refer people to us. And I will apologize for my laryngitis this morning. But other than that, I will wish everyone well. Thank you.
Well, Glenn, thank you. And I think you sounded great. I'd also like to remind people that on March 1st, Milton Chappelle, one of your coworkers, is also going to be with us to talk about release time. And I think that could be very interesting. And again, thank you so much, Glenn.